practical consequences of the PSD2 for personal data protection. My name is Joe Pierson. I'm chairholder of the chair which is organizing this panel, which is the chair on data protection on the ground. It's a chair we do in cooperation with the bank BNP Paribas Fortis and with support of also LSTS, so the research center which also organizes CPDP and also was originally initiated by the Belgium DPA. On the chair also is my colleague Ine van Zeeland, which I don't know where she's sitting, over there, yeah. She's doing PhD research on these topics. Briefly, the chair is about getting insight and doing research on practical best practices on privacy and data protection in a couple of sectors, one of them being, in this case, financial sector. We're also looking at health sector, media, and smart cities environments. Vertically, meaning what is happening in each of these sectors, knowing the specificities of the sector, but also horizontal, how do data privacy practices get successful in organizations? What are the bottlenecks? How to take care of this? Are all different departments in an organization on top of it, or is it only the DPO, and what can we do about these kind of things, approaching it in a practical way. Today, the panel, by the way, this is a kind of a follow-up of a round table we did in September this year with different stakeholders from industry, NGO, the government, regulators, and we had a policy brief for that, and afterwards we had a research report of that, so you can find some copies here at the front, but you can also download them. I don't know if the link is there. Yeah, it's there. It's a very long link, www.dataprotection.be. And so there you can find all the material we have done until now. So this panel is a kind of a follow-up, a deep dive into what we have delivered based on last year on the roundtables we did, given the fact that one of the key issues being in the financial sector, the new regulation this year starting being PSD2. In that sense, last year, I mean, of course, in that sense, so it's heavily criticized from a data privacy, data protection perspective, but also seen as an opener to innovation, and so there's a whole discussion around this, and this is the reason why we have this panel, of course. The panel approach is a little bit different than other panels. We have had some preparations before doing this panel. We had some talks about what are the key issues you guys think we should discuss in this panel, so I will, based on that, pose some questions to each of the panel members and hopefully get some nice discussion out of that. And in the end, having sufficient time for you to interact with us and taking the mic to also ask some questions or give some remarks. Okay, so let me first start then that each of the panel members briefly introduces him or herself, the position they have in the company or the organization they have. So let's begin on the left side, and first panel member.
Yes, thank you. Thank you, Jo. My name is also Jo. I'm Jo Coutuer. I'm the Chief Data Officer for BNP Paribas Fortis. And in that capacity, I'm responsible for data governance, but also for the usage of data, for instance, in AI. In the context of data protection, my scope extends to what we call the first line of defense, which would be ensuring that our data protection practices are really de facto implemented on the ground, as Jo called it, and that we comply, but most of all also that we live up to our customer promise towards our clients with regards to respecting their rights.
Okay, so hello everyone. My name is Anna Buchta. I'm the head of policy and consultation unit at the European Data Protection Supervisor. So for those who don't know us very well, we are the independent DPA for the EU institutions and bodies, but in addition to supervision and enforcement, we also provide legislative advice, including on legislation which has impact on the processing of personal data, such as PSD2, except that when that legislation was being considered, that obligation to consult with the EDPS has not yet been fully formalized yet, which maybe partly explains, but I will elaborate on it further, that we are now faced with a text with a, let's say, complicated relationship with the GDPR.
Thank you.
Good afternoon, my name is David Martin. I'm the team leader for digital policies at BEUC. BEUC is a European consumer organization. We gather 32 consumer organizations from all across the EU. We work on many different topics, including financial services, but also data protection and policy, where I've been working on this for the past 4 or 5 years on the GDPR, and also we work on enforcement actions, bringing forward cases. Last one we did was against Google last year. And I can see the issues that Anna was hinting, because we come from the two sides, let's say, from the data protection side, but also from the point of view of the financial services that are offered to consumers. And of course, we want to see that innovation, but of course we want that innovation is done in line with our fundamental rights and respecting our privacy. So there's I think, a lot to be discussed today.
Thank you.
Helena, Koning. I'm the Data Protection Officer for Mastercard, responsible for GDPR compliance in Europe, for example. So Mastercard, you all know, Mastercard is a tech company, but in the global payment industry. And data protection and trust, of course, are at the core of what we do, because payments can only exist in a system that is secure and benefits consumers, I would say. In my role, I've been looking very deeply into PSD2 data sharing and open banking. And as part of my role, I've been sitting on the expert committee of the European Commission on business to government data sharing. So what we are actually seeing is that we're going from open banking under PSD2 to open finance to open data. So perhaps we can elaborate a little bit further on that later on.
Indeed. Perhaps as introduction, as you are all here in this panel, I kind of assume you know quite well what PSD2 is. In case not, perhaps in two sentences, Anna, would you be able to explain what is PSD2 exactly? What does it aim to do?
Oh, well,
Just
I'm not sure
improvising.
Whether I'm the best person to explain this from scratch, but in bottom line, let's say from my perspective, so someone who looks at these things from the perspective of data protection, personal data protection, the PSD2 tries to open up the market of payment services in particular, and introduces certain obligations or possibilities for different types of new services and new service providers to enter the market through their access to banking data of banking consumers. And there we can speak about different groups of those providers, so third-party payment service providers, and there is some differentiation. But basically, this is about enabling competition, more competition on the market, as well as innovation through more open access to data that previously was closely held by a smaller group of companies.
Yes, exactly. So yes, that's so the main critique is, of course, then it's opening up a field which was kind of still protected on data, the financial data of people, to the big tech and the fintech sector, and in that way poses a huge risk, especially assuming that people might not always know what they are consenting to. But that's a topic we're going to discuss later on, consent. Perhaps we're opening up a question which we discussed when preparing this panel about the trust issue. So trust being kind of an essential thing for all companies, but especially for banks, you could say. How do you see this regarding the bank and the relation that you have with clients? I'll first asking you this as a company, and then asking the consumer representative, you could say. How do you see this in practice? How is this relation impacted, you think, or will it be impacted? The fact that it's their precious financial data, which you kind of card now is opened up to other parties, which might not be so, perhaps not be so sensitive or protecting with these kind of things?
Yeah. I first need to make a disclaimer for the record. My name is mentioned as representing Febel Fin, but I'm not representing the Federation of Banks. Okay, so I speak for as in my capacity for Fortis. First of all, I would like to say, you said it's a huge risk, and we can come back to that. I would like to also offer the privacy optimism. It's also a huge opportunity. It's an opportunity for the economy, for entrepreneurs. Banks are also entrepreneurs, so it offers an opportunity for banks as well, for a totally new ecosystem to create value for the market and for the people that use it and that benefit from that. When it comes to the factor of trust, we've been struggling. So my voice is that of the practice. So I must admit that we've been struggling to unravel this. Like, what is trust in this area? And we're coming now to the conclusion that we need to distinguish three factors. One factor is, what is our client promise? What did we promise, or what are we promising to the client? What is our reputation, and how is the world of reputation formers like the press, etc., dealing with this? And then what is regulation, a topic that is being abundantly discussed here, and regulation and compliance. It's interesting to realize, we're coming to the realization that to keep the trust and to keep the reputation, we might need to either stay in the boundaries of what people think is our customer promise, which is like, they think that it's, you don't do anything with our data, or that we need to actively start reshaping the customer promise, which could be, you can trust us with your data, not just your financial data. So we're a trust institution for data that you would not entrust to anyone else. That's one potential. Or another one could be, we will help you valorize your data in this new economy. What we realize is that new players that come into the market with PSD2 will have an easier job in creating a new customer promise, because they will be coming in the market. It's easier to come in the market and say, I'm a startup and I will give you a digital vault, or I'm a startup and I will monetize your data and I will give you a piece of the cake. It's easier because it's simple, and legacy banks are dealing with the problem of what is really the customer promise we made and how are we going to reshape it. And if you fail in doing that, you will harm your trust, you will harm your reputation. So I'm really putting the customer and what we mean to him or her first.
As a reaction, BEUC has very recently published a really interesting report about consumers, the impact on consumers, and possibly also on trust. What's your opinion about that, Dave?
Well, first of all, I'd like to say that this is a very important topic from the consumer perspective, because it's about the future of financial services, and it's also about the future of the digital economy more broadly, because what's happening here with PSD2 is going to become some sort of blueprint for what happens in other sectors. So we absolutely need to get this one right, because it can have a lot of consequences, not only on financial services themselves or in the sector, but also in other areas. And the issues we're worried about are not that different from issues that are of concern in the broader context of data protection and privacy. And trust and ethics always come up. And to be honest, I'm a bit tired of hearing all those with regards to the data processing or the data protection aspects, because we see that constantly this trust is being abused. I'm not saying that this is happening, but that banks are doing this at the moment, of course, but when we look at PSD2, the first thing that worries us is the access by the so-called AIS, the account information service providers, let's say. Because if you look at the type of companies that are looking for access to the data and asking for licenses to become AIS, you have companies like Google, for example, and other fintech companies which are less well known. And there are lots of different issues that come up there in in the sense of what happens with the data, and can you really trust those companies where all the information you see on the news again and again tells you that you cannot trust them. So for us, the issue really is less about trust and more about getting the regulation and the framing right, and making sure the rules are clear and that the rules are respected by all players. I think it would be a starting point, respected, and if not respected, that they are enforced. And this opens up a lot of different discussions. I'm sure we've all been having these days about the GDPR and others. But just coming back to the relationship, I think it's true that we're in a very specific sector because of the type of data and because of the type of service that is provided to consumers. So the relation that a consumer expects with his or her bank is not the same as what he would expect from other types of companies like big tech companies or fintech companies. And we need to be very careful with that aspect. But always, I would say that we shouldn't frame this in the first place as an issue about trust. First of all, we need to get the regulatory framework clear so that everybody knows what rules need to be respected and how.
What's the opinion of EDPS in this regard, you would say?
Well, I actually would say that you're probably both right. I also tend to be rather skeptical when people start speaking about ideals, ethics, and I always prefer to start talking about compliance with the law first, except that, well, unfortunately the law, as in this case, is not entirely clear. So then we need to, I think, collectively find a way of applying those rules or interpreting them in a way which would make them effective, efficient, and still be in line with the basic principles of the GDPR and the rule of law more broadly. And speaking of trust, I can perfectly understand, let's say, the certain nervosity on the part of the traditionally established market players, because obviously trust is very hard to earn, but it only takes one mistake, one slip up, or one rogue actor on the market to perhaps critically undermine the trust of consumers or potential consumers in the entire sector. And here I can understand that it might become an issue. And just maybe to finish off and set a little bit the perspective where the data protection authorities quite often are coming from in this field. Indeed, as it was mentioned in your introduction, banking secrecy used to be a thing not so long ago. So it was maybe not as elevated as medical confidentiality, but and there were problems, especially in recent years, problems in the sense of laws about data sharing with law enforcement or issues such as anti-money laundering, SWIFT and all that. But by and large, I think banks were trusted by their customers, but banks were also trusted by the regulators to basically do the right thing, because it was assumed that there was a common interest in treating the data confidentially, protecting them, and being serious about compliance. And incidentally, right now, just as we see that a little bit with health sector innovation, where this trust is perhaps still there on the part of consumers, but it's not necessarily fulfilled by everybody who is now entering this space. I think that this is also a major shift in terms of open finance and fintechs and all that. And this is a new situation for the regulators as well, who all of a sudden are faced with certain questions and issues with which there was a certain way of working with the market players and the actors and handling them for a long time. And all of a sudden there is a completely new framework in which we need to understand how to work with and how to approach as well.
Yeah, thank you. And from Mastercard?
Yes, thank you. So I think at Mastercard we really believe that trust is at the core of our business, and that actually trust and innovation can go together. So it's not innovation at all cost. And I think you need to be practical when you speak about trust. One of the things we're doing is extending GDPR rights globally, because we think that's the right thing to do. So actually giving people control over their data is essential, because that builds trust. And being transparent is one of those other things, so that people can understand what it means. What are you exactly doing with their data? One of the other initiatives that we are undertaking is, and they are online right now, is we've put out corporate data responsibility principles, because we feel that companies need to be responsible with the data they get from individuals. And so what does that mean? And so you will see that it means that we really think that people own their data and the data belongs to them. We feel that they should control it, that they have the right to understand it, and that they should control how it's shared and how it's used. We also think that they should benefit from it. And you see that in the recent AI frameworks, where it actually says that AI instruments should benefit individuals. And we engage ourselves to protect it, to keep it secure, and to handle it in a privacy-compliant manner. Now, how do you do this? I think in the back end, you need to have a very strong privacy program, and accountability and privacy by design needs to be embedded in the organization, because trust is not just a story. And specifically for the data protection officer that I am, it's operationalizing protections. And on that basis, I think you can build trust. Now, on PSD2. PSD2 is, of course, the idea is that it should push innovation and that other parties should be able to enter the market. But PSD2 has an all other piece to it, and we all know that. It's putting in place strong customer authentication. So it means that payments will be or are much securer with PSD2 in place. So what you see in PSD2, okay, well, we can discuss where the strong customer authentication.
Take up the question.
Yeah. So I think if you look at PSD2, it's not just opening data, it also at least envisages or tries to protect data in a better way. So let us be clear about that it's not only about innovation and banks that should be sharing data with others.
I'm going to touch on that issue then later on, certainly. But as you are speaking, you briefly mentioned extending GDPR globally. Would you say that PSD2 will do a little bit the same, that based on this European regulation that we will see this kind of having an influence much broader than only Europe, or is this...
Yeah, I think we're already seeing it, and we know that GDPR has global impact, and I think from a European perspective we see it as our export product, really, although it's not always understood well. And I think it's helpful, and in particular what's helpful about GDPR that we have both the ability to have data be transferred to other countries, but at the same time be protected at a very high level. So, for example, binding corporate rules, as we have them, allow you to transfer data cross-border, but also oblige you to protect it very well and give individual rights in that respect. And I think that is the strength of Europe, having very strong standards and then being able to export that. Now, open banking and PSD2 indeed is happening globally. So I've been very involved in what's happening in Brazil, a little bit on what's happening in Mexico now and in Israel, and of course Canada, and in New Zealand and Australia. This is also ongoing. And I think as an industry, but also more broadly, we really have an interest to get to standards that are more global standards. For example, if you think of open banking and the APIs that actually allow the transfer of data, we should standardize those APIs and make sure that the standards that we are developing in Europe actually have some value across the globe, so that we don't have to reinvent the wheel in every country. Now, from my perspective and from Mastercard's perspective, we have been thinking about what should those principles be that in all open banking laws across the globe should be implemented. What is really the basics? And for us, it's, first of all, they should be consumer-centric. So in PSD2, you see consent and you see other rights. It should create a level playing field. And I think that is one of the issues with PSD2. It doesn't have reciprocity. I think if you want to do it right, it should create a level playing field and have reciprocity. We spoke about interoperable standards. Then it should have world-class security. I mean, that's the least you can do. Make sure that people's data is secure. And then it should fully align with privacy and consumer laws. And that is one of the issues with PSD2, that the alignment, the consistency with GDPR is not in place. So let me stop there. But I think there is real interest for also PSD2 to be exported. And we already see a lot of interest from the regulators across the globe to implement a sort of PSD2.
Thank you. Do you agree with it, Anna? That it's kind of can be still also become seen as a new thing, also playing globally from a European, starting in Europe?
I don't. Well, it's difficult for me to say yes, no. I guess the practitioners who have an overview know it best. I have to say that for now, we have been mostly working with the EDPB, so within the European Data Protection Board, with other European data protection authorities on guidelines on PSD2 and specifically on the points of interaction or contact or conflict with the GDPR, but we have not really been conducting surveys of broader situation. However, I believe there is a lot to support this, even if we just look at what was referred to before. There is clearly now growing push towards open finance, open data, open sharing, everything in various areas. And I do agree that PSD2 is probably a first opening salvo in this area, and it's likely to be emulated in some form in other areas, and probably also then in other jurisdictions, yes.
Yeah. Do you agree, Joop? Because BNP Paribas is a global player also?
Yeah, well, obviously we're facing the same practical problems. You could say as a principle, it should be standardized, it should be global, but it's also from a selfish cost perspective for a global organization. There's every advantage to have that, but also the clientele is becoming increasingly global. So it's not just selfish motivation from a corporation. It's also the easiest and the best way to deliver services and products, innovative products, to a clientele that's becoming increasingly mobile and global. It will have to happen, or it will take a very long time if it doesn't standardize. The innovation will really be hindered by that. I just want to support the point about reciprocity. To realize the dream of PSD2 becoming the blueprint for a global open data economy, I think the reciprocity issue might be at the heart of everything. This will need to get fixed, or this beautiful flower of open data will not flourish, I think. I don't know if it's clear what we mean with the reciprocity.
Yeah, just a little bit what you mean by it?
Yes, what I mean by it in non-legal terms is the fact that a financial institution, traditional as it may be, as guardian of the client's data, and I stress that we should not say the bank's data, it's always the client's data, but we're the guardians of the client's data. We need to be the enablers of an opening up of these data towards other players, by which they can offer financial services to the clients. Reciprocity would mean that a financial institution should also get the opportunity to deliver the other services that other players are offering. Take Amazon. If Amazon wants to offer insight services in financial data, then why should a financial institution not be able to use the APIs or the advertising services or the advertising algorithms or data of Amazon? That's reciprocity, because in all fairness, it's not to be an underdog, but it puts a sector in a disadvantage without giving anything back. And in an open market, you need reciprocity to allow it to flourish.
Does it then also relate to the fact of having very different regulatory regimes? As you once mentioned to me, that banks didn't really need GDPR because you are so heavily audited and regulated on data that so. And comparing this with the tech sector or others, they are much more lightly regulated in that sense?
Yeah, well, before you put that on LinkedIn, and I said that we don't need GDPR. What I said is because I really love it, because it has brought a general awareness to the general population of the bank. But I also said it's not been the big jump that it might be for others, because the concept of privacy and compliance and being legal, and I know there's a lot of distrust, but it's very hard to be entrepreneurial in a bank because it is probably the most audited and watched sector in the world. So that's why I didn't start with compliance when I gave my point, because it's so obvious for me. And I agree with my colleague, said regulation and enforcement should be first. Yeah, because I wake up with that in the morning. It's obvious. So GDPR acted to a large extent as a leveler of the playing field, but PSD2 is a bit again unleveling the playing field, yes, without reciprocity.
Point to make it more level playing field. Yeah. Do you agree with that, David? That regarding level playing field?
It's certainly a difficult discussion, and it's reminding me a little bit as well of what's happening in other sectors like telecoms, where the traditional telecoms industry is basically complaining that they cannot do all that the same things that the new players coming into the sector can do with the data, and that they are more regulated, should be less regulated. Well, there might be a reason for that as well, because of the specific type of services which are supposed to be their core services. With that, I don't see, I think that the answer should go more into making sure that those new entrants have to comply with the same type of, similar type of obligations as the traditional ones, rather than lowering the bar for everyone. So I guess, yes, there's some sort of uneven playing field at the moment, or there can be, but we have to be very careful with how we level that playing field, because the consumers and their data is in the middle. And basically, it seems like it's a ball that's been thrown to one side or to the other, and everybody wants to be able to play with the ball. So I think it's important that it's the owner of the ball that decides who gets to play with it.
Yeah, but he needs to be able to decide, and the lack of reciprocity doesn't allow him to decide what happens to the algorithms of an advertising company, where he will be able to decide what happens to the algorithm of the financial industry. And don't get me wrong, I'm not speaking about lowering the bar, not at all. And again, I said jumping over a high legal bar is what we do for breakfast. So that's not our concern. It's what services can we deliver to the client, and why can we not deliver those excellent services that they're used to from other companies, and not just boring financial services.
Which are kind of important, by the way.
You
Exciting as they may be, I'm just provoking.
No, I think what you're doing is important, because you're putting the consumer at the center of it, and the innovation that is possible with those new data sets is incredible. And I think what we want is, we want to protect individuals, we want to secure their data, we want to make sure that their privacy is protected, but we also want to offer them innovative services. And I think that is the promise of data sharing, and that's also the risk of it. So we need to do this in a right, regulated way.
Absolutely.
Just quickly, just to be clear as well, we are supportive of this type of innovation, but we want to make sure that it happens in the right way, as you say.
Coming to the third point, which we kind of prepared, and it's kind of a crucial point in the discussion here, I think, and also linking it to when does innovation for the consumer, citizen, client can happen, is quite central in the PSD2 is, once they need to give consent. So the issue of consent is a typical one of the legal grounds we have in the GDPR, but in the PSD2, it's also being framed, but there is some discussion legally about what does consent between these two types of regulation mean. EDPB has sent a letter to the Parliament about it, how we should interpret that. In the report of BEUC, I always forget how to pronounce it right.
It's a matter of consumer choice, don't worry again.
This is also discussed intensely. What does it mean? Perhaps you can start, Anna. How would you frame this?
Yes, thank you. Just very briefly, and then probably David can also supplement, because I saw from the paper that we have quite complementary views on this. I mean, first of all, I should say, yes, we have the PSD2 directive. We have since then also the GDPR that has been adopted later and entered into force a bit later. Nevertheless, it's directly applicable in our member states today. And well, unfortunately, the interaction between those two texts is not entirely clear. There is a provision, as many of you would know, Article 94, that pretends to say something about the data protection regime within the PSD2, but it's not very helpful. It seems quite incomplete, and it's also a bit confusing because it still refers to the old Data Protection Directive. So obviously, as lawyers, we know that nowadays the references to the old directive should just be replaced by references to the GDPR, but unfortunately that does not in itself answer any questions that arise here. So the issue about, or the doubts about consent probably stem from the fact, a very simple fact, that PSD2 also refers to consent and to explicit consent in several occasions. And already around the time when the directive was voted, there was the negotiations of the GDPR, where also, as you may remember, there were long discussions about consent and what are the conditions for valid consent and whether it's only unambiguous or also explicit and all these things. So now we have two quite high-profile legal texts, both dealing with consumer data of quite sensitive category, and both use the terms consent and explicit consent. And yet, this all doesn't mean that all those terms mean the same thing. So even though PSD2 also speaks of consent and explicit consent, this does not mean that those terms should mean the same thing automatically as they mean, or play the role which they play in the GDPR. So bottom line, and this is something that we as data protection authorities, we have agreed among us in a context of questions asked at some point in time by a member of the parliament, Mrs. Sophia Netveld. And indeed there was a letter which is available on the EDPB website and which you can consult from July 2018, and which makes this precise point. So consent in PSD2 is basically a contractual consent. So that means that the individual has to agree to give access, in this case, to their data. But this is an additional safeguard. This is signing a contract. So the way that PSD2 then elaborates on what exactly needs to be consented to, this should be seen as an additional safeguard, given making sure that the consumer really understood what they are consenting to as part of the contract. And so the corresponding provision of the GDPR, or the consequence of that in the framework of the GDPR, is that in many cases under PSD2, the actual legal basis for the processing for personal data would be contract, or what we call contractual necessity. Okay? So if anybody tells you, no, but PSD2 is lex specialis to GDPR and it just tweaks the consent a little bit for the purposes of this sector, no. There is no relationship of lex generalis, lex specialis. It's two different acts. We need to find a way of interpreting both of them, but bottom line is that consent in PSD2 is a contractual legal basis, and the corresponding one in the GDPR would not be consent, at least not in all cases, but it would be contract. And just to finish off very quickly, that does not mean that there is no space or room or requirement for explicit GDPR type consent under PSD2. There will be cases, there will be situations, categories of services or categories of data that would still require proper explicit consent and would be processed on the basis of GDPR consent. But
just to be sure, what is the official status of this letter? Is this something?
Listen, this is a public letter. This is something which the EDPS agreed at some point as a position and published on its website. So I would say it indicates the current thinking about some of the elements. But as I probably already mentioned earlier, or at least I meant to mention, the EDPB is currently working on guidelines, which would be more all-encompassing and which would consider the issues of consent, legal basis, silent third party, and some other questions in greater detail. And so those guidelines will have the official weight of, GDPR Article 70 guidelines, but they are not available, they are not finished yet.
Okay. How do you see this as BEUC?
I think Anna explained it very well. So I will complement from our point of view, because now the thing is of course, the authorities which are in charge of applying PSD2 are trying to interpret or say how this should be applied and what all these concepts in PSD2 mean. And what we would like to see is that, in addition to what Anna explained, we agree that we're talking about two different things. Explicit consent under PSD2 is a different thing from consent under GDPR. The legal basis for processing for most of the cases would be the contractual necessity in this case. But then what does explicit consent under PSD2 mean? How does that look like? And from that perspective, we are asking that the regulators actually take inspiration from the GDPR, and that the standards applied to that explicit consent are similar to the standards that would be applied to consider whether consent would be valid under the GDPR. It has to be informed, freely given, etc., etc. I don't need to go through all of those. But basically, that's what we would like to see, that this consent is held up to high standards so that the consumer can actually have an idea of what's happening, what he's giving his agreement to, and also that they can have some degree of control. Just to mention one thing, to finish on this point, Anna was mentioning that in some cases you would need explicit consent under the GDPR as well. And this is an important point from our perspective, because even if it's true that financial data as such is not included in Article 9 of the GDPR as a special category of data, it can reveal special categories of data. And we have to be aware of that. So in those cases where this type of data might be revealed, you would need the explicit consent under GDPR, because there's no contractual necessity for special categories of data. And this also opens up another issue, which maybe we can talk about later, which relates to data minimization and the fact that the PSD2, when you give access to the data, you give access to the whole set of data, so basically everything in your account. And there we're going to need technical solutions to actually separate, I think, special categories of data so that they are not processed when they shouldn't be processed. And just last point on the issue of the banks and consent, we think that there's a problem in terms of the interpretation that has been given so far from the EBA, because if I, as a consumer, give consent to access to my data under PSD2 to a third-party service provider, the bank apparently cannot verify that I have given such consent. At least that's how we understand the system works. And we think that this is basically this is kind of nonsense. It's a security problem here and should be fixed.
You wanted to react?
Yes, so perhaps on the last point, so if banks have the impression that there is a case of fraud, they can refuse to transfer the data to the third party, so I think that's important. The other thing to perhaps clarify is that the legal basis for the third party that receives the data to process it and to use it, as described under PSD2, is indeed a contractual agreement. The legal basis for the bank to transfer the data to the TPP is, in my understanding, is compliance with a legal obligation, because PSD2 obliges the bank to transfer it. I think that's good to remember. Now, if this third party wants to use that data for another purpose than described under PSD2, you immediately fall back to GDPR. Yes. And we all know Article 6.4, and we have to apply it. Now, very often, thus you will have to obtain explicit consent under GDPR for these new uses. But you can also imagine other situations. For example, the TPP may have an obligation to comply with other laws, AML, KYC, or what it may be. So, of course, very often another use is explicit consent, but there may be possibilities that there is another basis for it. That's what I wanted to add.
I need to apologize for being the least legally educated to my panelists and to the people in the room. And it's a nice illustration, and I'll play a role more brutally. It's like, so what do I do tomorrow? And how do I explain this to an analyst who needs to write a document so that a programmer can decide where he's going to put what on a screen in which app? That's our practical challenge. So all this is nice and true, and then it needs to find its translation to very mundane things. And even more mundane is, what does a consumer understand of this? Because I would like sort of to challenge the idea that by just being compliant, we'll do the right thing for the consumer. That assumes that people who have written and interpret the laws have the truth about what is good for a consumer in their minds and in their pens. The consumer might not totally agree with that. First of all, a consumer might not understand that we're acting in his interest, and he might not think it's in his or her interest. Neither do journalists, and I come back to my earlier point about reputation and customer promise. This illustrates that they go hand in hand with legality. You can not substitute legality for one of the others. You really need to balance these three acts if you want to get something implemented in real life. And it's a damn hard challenge to do, to make sure that the law is respected, that your consumer feels respected, and that your reputation remains intact. Very complex, and this is, I think, this debate is an illustration of that.
What do you think? Can this indeed, David, be meaningful explained, given the legal sophistication of the case to an ordinary consumer when what he decides to give that data and to what he is in fact really consenting or not, or under some kind of whatever?
Well, here we're getting into a debate that is also related to GDPR as such, and not only PSD2 and the issues around transparency and consent and what are the limitations of those models, and the fact that it's, at least in the way things are working now, it's very, very difficult for the consumer to actually understand what's going on, to give meaningful consent. Also, I must say that there are lots of parties out there that don't make it easier for the consumer neither. When you look at how certain interfaces are designed, for example, everything seems to be designed somehow to get from the consumer what you would like to get from the consumer.
The dark patterns.
Exactly, the dark patterns. So I think that there's a lot of work to do, and probably a lot of things that can be done much better in terms of how you give information to consumers and what types of options you put in front of them. But it's important to keep in mind that the burden shouldn't be always or only on the side of the consumer. These are very complex issues and complex, let's say, activities that are going on and different parties involved. So I'm not saying it's easy to do that, but I think that a better job can be done. And also we need to think beyond the elements of, okay, consumer consent, that's it, tick the box, that's fine. I think that we also need to make it easier for the consumers in terms of how everything is designed, and the whole issues about the settings and the privacy by design obligations is very important. And also, eventually, you are going to have to think about whether you need additional limitations for certain things. I mean, are there things that you shouldn't ask the consumer whether he or she is okay with them? I mean, I know it might sound very paternalistic, but in some cases there are issues that you need to probably add stricter regulation. Of course, that's going beyond what we're discussing now. But to come back to the original point, I know it's a hard, or we know and consumers know it's a hard exercise. We know it's complex, but we have the impression that, let's say, the businesses can do better on a lot of different practices, and that if we start with that, probably things will get better, and then we'll see where it takes us.
Okay, thank you. So we have almost 25 minutes left, a little bit less. I want to give the opportunity to the audience. If there are questions, I would like you to take the mic, or if the mic can be broad, I don't know. It's, also your question which you raised about authentication.
It's more a rant, I don't know if it's
really okay. Ranting allowed.
I have two roles, like being a security consultant, being a privacy activist, and being an actual customer of banks. So it's like, it's really, there's lots of...
Yeah, but let's take it up. Bart Jacobs, you have been involved a lot over the couple of last years with PSD2.
Yeah, I have a couple of short questions and remarks. First to David, you were rightly complaining about the fact that consent cannot be transferred to banks. The technical solution for this is to use digital signatures. And really, this is an application that's crying out for usage of digital signatures, such that consent can really, together with the signature, be transferred. I have two questions to Anna. First, a very short one. I was under the impression that the EDPS is preparing an opinion on PSD2. Is that right? Or
It's the EDPB.
Oh.
EDPB is preparing guidelines on PSD2.
Okay.
We are working with them because we are one of the members, and we are actively participating in the expert group.
Oh, okay. I thought you yourself were also preparing an opinion, so I'm not incorrect on that.
No, not that I know.
Okay.
We usually have our hands full with preparing opinions on forthcoming proposed legislation. This is our primary role, and sometimes about prospective issues. But here, since the EDPB is already working on it, we are working with them towards the final guidelines.
Very good. So then a more substantial question. You're all talking about protecting consumers in this. Well, I'm very worried about this because lots of responsibility is dumped on consumers with PSD2, and lots of institutional protection disappears. My classic example is that maybe in 2 years' time I want to travel to the US or to China, and I need visa for this, and those countries may force me to open up my bank account under PSD2. Who will protect me? Is this request for consent, because I will have to consent to this? Would that be legal? I guess not under GDPR because it's not really freely given. But is it valid under PSD2? Or how would this happen? How would this be handled, such a situation? Would there be a European body to step in to protect me in such a situation?
Yeah, maybe to the last question, I'll leave to the floor. But first of all, we need to realize that there's already a lot of governmental scrutiny on financial data. Enforcement of anti-money laundering means already that all our transactions are screened permanently.
Yeah, maybe by my own government, but not by the Chinese government.
Not by the Chinese, but that's because they don't control the US dollar, but the American government is very much embedded into the global financial system and into the enforcement of anti-money laundering and terrorist activity, etc. And that's because they have the power of the dollar.
Yeah.
Okay? Because the yuan does not have the same...
So you're saying they will not ask me because they already know?
I wouldn't go so far, but you're exaggerating a bit, but yeah. And then, yeah, how we will protect you? Honestly, I don't have the answer because they impose laws on financial institutions, and you either choose.
No, sure. You're not the one to answer that.
Your concern is legitimate, I think.
Yeah.
But I'm not sure whether I understood you well. Are you suggesting that the Chinese government would use the legal means under PSD2?
Oh, they would hire some company that has a PSD2 license.
Yes.
And then ask that company to put me that question. Just if you apply for visa to the US now,
Yes.
you have to interact with a credit card company.
Yes.
That does the processing
Yes.
for the US
Yeah.
government. They can put in between a company that has a PSD2 license and tell me on the visa application that I have to consent to this government, to this company in between, this intermediate company, to give my financial data to that company, and then that company will pass it on to the US government.
And you're already strongly encouraged to give your social media data as well.
Yes.
I know, but you're deflecting from the core question. You're making it bigger. I would like to stay on this question itself. Anna, do you get my point now?
I think I do, but I really do not see how we could fix it or really help it.
So we're lost. I'm lost in this situation.
So I think if you look at it from a legal perspective, what I try to do is companies are bound by GDPR. So we cannot, even if you transfer data globally, you cannot just transfer data to a government entity. GDPR has very strict requirements on governments. So if, for example, there is a conflict between GDPR and a foreign law, which in this instance would exist, all European companies are obliged to go and see their data protection authority and say, you know, what do I do with this? Because this foreign government is forcing me to share data, but I am not allowed to do so under GDPR.
Yeah.
So it's not like there is an open door
And who
to
would solve
sharing
the
data.
issue then?
Yeah, but this is not
solve-
how I understood the question.
No.
I understood.
Same thing that you have in GDPR.
Yeah, but I understood the question as, you know, if I want to get a visa to travel to China, and I'm obliged to give some contractual consent to something in this context. I mean, I'm sorry, there is a reason why some people don't go to China or don't do business with China.
So that means that the result of PSD2 is that fewer Europeans travel to China because they don't want to give up that data.
Nobody will understand
No,
that.
I think, sir, that the what you are referring to is a true issue, but it's not PSD2 that opens the door. It
But
is
the
actually.
PSD2 offers the means to open that door.
I would not think so personally.
Because otherwise the Chinese government has no means to get access to my bank account.
Yes, they have.
Well, not via me directly. No, not via me directly. Yeah.
You shouldn't overplay this. It is the general thing is right. It's like the forced consent in general, also not just to the Chinese government, just to companies in general, because the governments they have other means, and this is like I totally agree. There are totally other ways to figuring out who you are, what money you have, who you're dealing with. They don't need PSD2 to actually get you your data.
No, I think that's a side issue.
But it's not a side issue.
And it was only an example of how people can be put under pressure because because issues are individualized, and big companies can handle individuals. They lean on them until they agree, and that's the whole thing. Institutional protection is disappearing.
I'm not.
Forced consent in general, it's the same with GDPR. Someone says you can only use that service if you give me the data. If you don't give me the data, you don't have the service. That is. No, but
yeah.
Yep.
It's even
But
stronger than the GDPR part because it might, like, you know, I have trouble because I don't give consent. So
Yes.
it means I can't use a service, and my bank says, "Oh, you do fraud," and I say, "No, I don't do fraud. I just don't want to give data to these people." This is real issues, but it is not so much with the Chinese government.
Yeah.
There are other.
No, it's just an example. I don't care about the Chinese government.
Yeah, but I think the gentleman, I would like to support you, but I'm more worried about the ease and the laziness, and I'm sorry to sound paternalistic, but if my 18-year-old tomorrow gets the opportunity to send a payment to his friends or her friends using TikTok as an app, they will do it. And they will not hesitate for a second and think that TikTok is Chinese, and that's the problem because so.
Sure.
And I don't see. I think you're right, but I don't see how we can stop it.
Okay.
I think you're right.
So my conclusion is you agree I'm right, but most of the answers I get are about something else.
No, that's not true.
You
PSD2,
TikTok and
PSD2 would allow TikTok to become an information provider or a TPP.
Yes.
I, as a bank, cannot, if they comply with all the rules, I cannot stop them, provided they comply.
I know there's someone else, but I still have another question. You go first.
Yes, thanks.
Two of us, you thank you very much for the incredible explanation on legal basis, first of all. It was really good, so thank you for that. I'm Sebastian Barjval. I work at VDA Law Firm. And I have a couple of questions, one for Jo and one for Helena. So for Jo, I was thinking that it must be really hard to develop a standard API for granting TPPs with access to personal data that you have stored, particularly for the reason is that to comply with the principle of minimization while granting access to the data, each TPP needs different data to provide different services. So how can you complying with data minimization privacy by design if you want to have a standard API which grants access to all TPPs if they all need different data to provide services? That is one question. The other question to Helena is how difficult have you found the access to APIs until now? Because we know that banks should have implemented APIs until September, but probably some of them haven't yet, or they don't comply with the requirements of the RTSs. And in that case, have you relied upon, if the TPP, if the APIs are not in place, with alternative mechanisms to access customers' accounts, notably through fallback mechanisms using customers' credentials? Because there seems also to be an incompatibility within PSD2 as to a sensitive payment data, which includes customers' credentials, and payment service providers shouldn't access those credentials. So I'm wondering, how are you in practice dealing with this apparent contradiction? And I'm looking forward to hear your answers. Thank you.
Thank you for giving me the easy question. Given the, first of all, PSD2 is not, it's not all potential banking data. So fortunately, the scope is rather, it's possible to handle the scope, and the potential variations for us on that scope are also not in the millions. I think a big topic is about, do you have an API where you have the data of, what's it called, the silent party? Do they need that? Do you need to minimize that? And in another, or do they need it, and do is it contractual or is it consent that you need to give that information? So that's already two big families of APIs, with silent information or without. And then another debate that you typically have in bank transactions is about the description field. But just to say, it's not like we would need, with the current scope, millions of permutations of APIs. So it's not on my top concern right now.
So let me try then to answer your question. I think the first thing I would want to clarify is that Mastercard is not a TPP, so we are not a third party. What we are actually doing is we are a connectivity provider. So we are trying to solve for the fact that TPPs would need to connect to a lot of banks, and banks would need to connect to a lot of TPPs. And so we're sitting in the middle, and we're trying to provide safeguards and controls to both phases of the spectrum. And I think that is what is actually interesting. And if you have a little bit of a broader look, that is what you see happening in data sharing. So you see new schemes developing that provide connectivity, that provide dispute resolution, and have frameworks for liability. So you see it, for example, in the transport sector. The Port of Rotterdam now has a very interesting data sharing scheme. Now, I agree with you that screen scraping, and even the screen scraping 2.0, I think it's called under PSD2, is not a good solution. In particular, it's a terrible solution for privacy people. And of course, I can only guess, but one of the issues I see with PSD2 right now is that it allows for a certain form of screen scraping, while privacy regulators are fundamentally against the sharing of credentials. And so there is some conflict there.
Okay, thank you.
Thank you. Next question, please.
Everyone was very tall. Hi, I'm Dana. I work in Privacy One. I'm a lawyer. We have a privacy law firm. I wanted to ask you about strong customer authentication. That what we see is that fintechs and also more classical financial institutions are very trigger happy to use biometrics for authentication, not for identification, understanding the difference between the two. But sometimes data protection authorities don't necessarily understand the difference between the two. So my question would be, do you think it would be legitimate for a fintech, for example, who wants to be a TPP, that they only have a system of biometric authentication for their service, or would it is necessary, or would it be mandatory for them also to have a fallback option to provide customers with the choice for them to use their biometric data or not? And then there's another point which is really kind of bothering me, that we have strong customer authentication, but also we can have an exemption from the SCAs. That means the card issuer can provide me the choice to rely on those exemptions, but that means that they are supposed to process some of my purchase data or other types of online behavioral data. So I wanted to ask you if you see any types of risks or problems with that particular component. Thank you.
Just maybe on the biometrics, as a data officer of a bank, I would run away and shy away from storing people's biometric data, first of all. That doesn't mean I can log on to my banking service using the face recognition of my iPhone, but I'm not storing the biometrics of you as a client. So I wouldn't engage in that, and I would be very weary of people wanting to do that.
5 more minutes.
Yes.
So, yeah, if I can add something to it, it's my understanding that the TPPs are relying on the banks to do strong customer authentication. So, of course, the banks can have some kind of agreement with the TPPs that the TPPs do it themselves, but it is the responsibility of the bank. Now, on biometrics, I totally agree with Joe, is that biometrics needs very strong privacy by design implementation. It should not be stored on one server, and even it should not be stored as is, but it should be stored in a template form. Now, if you're speaking about transaction risk analysis, which is also mandatory under GDPR. That is a way to assess levels of fraud. And then if the levels of fraud are really low, there is a possibility to not do strong customer authentication. And that is really to facilitate payments when the risk is very low. So in a way, that's in line with GDPR, which has a risk-based approach. If the risk is very low, then the safeguards and controls can be different.
Okay, thank you. We have a last question.
Yes,
Gentlemen?
yes. So the banks are all over Europe are now building fancy APIs that the new companies, PSD2 companies, service providers can connect to. Are they going to open these APIs to their customers themselves as well? Because there's a silly, when you think of it strategically, why would I have to go as a customer, go through a third party to get to my data? Why can't I directly connect to the API of the bank if I have proper authentication with the bank organized?
I think today, you're right, every bank has a way of giving you back your data. It could be an Excel file or a CSV file. Honestly, I don't know if there's legal... for me, an API would just be another format of the CSV file that I get today, so I wouldn't see any objection there. But you cannot... It's not like making an API public. It's not the same thing as putting APIs public as you have in another API ecosystem. So you'd need to find a way to make sure that the API is only executed within the one-on-one relationship with the client.
Probably you have.
But for me, whether it's an Excel or a CSV or whether you call it API, which is actually a CSV.
Yeah, I appreciate this openness. This is very interesting. This offers new opportunities then, where you can really empower people that they can directly talk to APIs of the banks. I think for consumer organizations, it would be also an interesting perspective.
I think
yeah, but if I just, I'd like to dabble with programming language and then play with APIs, but we need to realize from the 3 million clients that we have, for their individual data, very few will call an API. So normally an API is for the development community or for other parties to build applications on top. So
I understand.
So it's not really a priority in my roadmap.
No, I understand. But suppose I would come to you and ask for it, you would be willing to look into it?
Yeah, but we have to prioritize developments. So conceptually, yes, but we need to decide what we prioritize, and there's no demand for that.
Interesting.
In the 3 million people, unless you want to make an application, then you need to become a TPP or an AS.
Yeah.
No, I just want to make an application for myself. I want to build my own app, and then.
If you want to build your own, then you'll need to. But then you'll need to follow the legal procedure to comply.
Why? It's my
because
own
you're an app builder. I don't know what you're going to do with the app.
No, I only keep it on my own phone.
I cannot know that.
Oh yeah, okay. But
you should be scared if I said the opposite.
Sure. I'm testing you. Of course, we need to have a one-on-one relation. I need to have a certificate, but I can get one from Let's Encrypt for free, etc. There's a consumer market for this, but maybe.
No, I was just going to make a general point that this reminds me of the issues related to personal data management systems and this type of services that can help consumers actually manage their data directly. Of course, this opens up opportunities and benefits for consumers, also risks if you open the data for more people and more people are in between the different providers. And it's an interesting area. Of course, it's for very certain types of consumers that are going to be able to grasp all these issues or build apps themselves. I mean, but it's already complex enough as it is. So.
I mean, but everyone is talking about putting the consumer-centric things. This is consumer-centrism pushed to the limit. Right? So I'm just taking literally what you're saying.
No, but I think then you should create a market. You should convince an entrepreneur, or you become an entrepreneur to build such an application to the benefit. No, it's not to ridiculize it. They are popping out of the ground like mushrooms. Enterprises who empower the user to manage his own data, and they will need to go through the same procedures as all other solution providers. So it's not a point-to-point consumer. Consumers.
No, I disagree. I disagree that there should be a third party in between. I want to get direct access. Even if I have a company, I as a company want to talk directly to your API. And maybe there's a third party that gives me the software to do so, but I want to be the one who's talking to you as a bank.
Again, I'm not disagreeing in principle. It's just a matter of priority. So I
okay.
agree with you in principle.
What is interesting, sir, is you are pointing to something that under GDPR we call data portability.
Sure.
And what you are actually
that's
requesting,
one way of translating it.
and what you are actually requesting is saying that data portability right should be much easier to use, and it should perhaps be a real-time possibility for individuals to get access to their data. And that is what I understand actually from what you're trying to get at.
To be more precise, I'm asking for the data portability right via the PSD2 interface, but maybe not only just one way giving the data to me, but also giving transactions to the bank, if there's a proper authentication mechanism for this. So data portability is only one way. I'm going beyond this, but I think we should.
Thank you.
So thanks for this elaborate discussion. Unfortunately, our time is up. We had some other points we could make, talking about collaboration between different authorities and other things, but we have to stop here. So in that way, join me and to thank the panel for their really interesting contributions.